Happy Friday. So, we're going to talk about office actions today. What is an office action? An office action happens when the examiner attorney finds something wrong with your application. Now, some people think that if you just do it yourself, you get an office action. Like, everyone can get an office action. If you do it yourself, you can get an office action. Attorneys get office actions. Anybody can get an office action. As long as the examiner attorney from the USPTO finds something's wrong with your application, they will send you out an office action. So we're actually going to look into an office action today. So many of you guys know, of course, LeBron James, but he actually filed for a trademark application for his daughter's YouTube channel, All Things Zuri. All right, so it came back and they received an office action, and they even had an attorney to file the application. Now, in this instance, I'm going to tell you guys exactly why they got the office action and what the examiner attorney told them to do. We're going to look. So they actually received the office action because All Things Zuri, the examiner attorney said that if there's a person using their name, they must get written consent, and they actually have to put that with the application. So according to the attorney, I'm trying to read this essay to you guys. It says, because the individual named in the mark did not sign the application and the application did not include a proper written consent, applicant must provide a statement that the name in the mark identifies a particular living individual and a written consent to register the name. And you can see the reference to blah, 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 blah. Okay, great. So now, what most people don't know, guess what then the examiner attorney tells them to do? The applicant must submit both of the following. Now, he's telling them what to do. I'm not telling you guys what to do, but the examiner attorney is telling them what to submit. The following statement: the name shown in the mark identifies a living individual whose consent to register is made of record. If the name is a pseudonym, stage name, or nickname, applicant must provide the following statement. The specified assumed name identifies specified actual name, a living individual whose consent is of record. And then they also say a written consent personally signed by the named individual as follows. I specify your name, consent to the use and registration of my name as a trademark and or service mark with the USPTO. Not only that, guess what they do, y'all? They reference where you need to go to find more information. They also say for an overview of the requirements for names, appearing in marks, and instructions on how to satisfy this requirement using the online trademark electronic application system response form, see the name, portrait, signature of particular living individual in mark webpage. So they actually refer you to a website to get more information to submit the appropriate information. And not only that, if the individual is a minor, let's continue to read on. If the record indicates that the person whose name or likeness appears in the mark is a minor, the question of who should sign the consent depends on state of law. If the minor can validly, I can't even say that word, y'all, enter into binding legal obligations and can sue or be sued in the state on which he or she is domiciled, then the minor may sign the consent. Otherwise, the consent should be signed by a parent or legal guardian, clearly setting forth his or her status as a parent or legal guardian. If the record indicates that person whose name or likeness appears in the mark is a minor, the examiner attorney must inquire as to whether the person can validly enter the binding legal obligations under the law of the state in which he or she is domiciled. If the minor cannot enter into binding legal obligations, the examiner attorney must require consent by the parent or guardian. And then they reference how you can actually see this information on the USPTO website. Okay, so then they tell you how to respond to the office action. Now, why is this important? Okay. I'm here to tell you guys the trademark truth. Okay. These are the hidden gems that we're going to be talking about in our virtual boot camp next oh my gosh, the July 20th to July 23rd, of how we're going to actually go into the system and read what's going on with the USPTO and the trademark document retrieval system. Okay, so if you guys have not already signed up for the course, make sure you sign up for the course. The link is in the bio. And not only that, this can, of course, every situation is different, but this just shows you that the trademark attorney sent out an office action, and now they're telling you exactly what to do with this office action. Now, what I've seen, when most people get an office action, they just run, and they never, ever reply back to the examiner attorney. Don't let that be you. Call the attorney who is handling your case and ask them about it. Just call them up. You can email them or you can call them, because look, they're here to help. They can't give, of course, they can't give you the legal advice and tell you exactly what to do, but they are literally referencing how to write consent right there in the database that everyone can see. So, hope you guys have a great day, and I hope you guys learned something today.